Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn, at BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208 493 7345. Or you can send a text 07950 422 780. It's The Community and the Law. My name is Oreku Frimpong, and I am your host. It's another Saturday afternoon here with us, ladies and gentlemen, and welcome to The Community and the Law, brought to you live on BWTV and sponsored by BWF Solicitors. There's a saying that I love so much: a stitch in time saves 9. This time I am adapting that to the realm of immigration issues here in the UK. A stitch in time. What to do to prepare for the new settlement rules in autumn. We are in spring, we have entered summer, and autumn will be following. New things, new rules coming, and we are jumping into it to have a sneak preview into that. Lawyer Charles Asma will be helping us to do that preparation in a discussion live on TV. The Community and the Law is next.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Yes, 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 yes. The sun is out, so golden in the sky. It's another Saturday, and we are live with you on BWTV. My name is Oreku Frimpon, and I'm bringing you the community and the law with BWF Solicitors. This afternoon, we're going to have a sneak preview into what will be happening in the autumn 2026. A stitching time, what to do to prepare for the new settlement rules in autumn. Lawyer Charles Asma from BWF Solicitors will be our resource person this afternoon to take us through that. And I said earlier in the introduction, I said that we are going to help ourselves prepare to meet the new rules. You know what? Change is the only constant in this world. So if it is that there is change coming, you have to prepare yourself to brace it and then make sure that you live with it the right way. And when it comes to immigration matters, when it comes to settlement rules here in the UK, you can't trust any other person or any other organization better than BWF Solicitors. They are located on the fourth floor of the Anna House, 214-2218 Tottenham High Road, Seven Sisters, North London. If you drive in, the postcode is N15 4NP. If you come by public transport, get on the underground and use the Victoria line, get off at Seven Sisters train station, use exit number 2, and it will bring you to the frontage of the Anna House. Climb up to the fourth floor and you meet BWF Solicitors. They work Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. And you can call them on 0208 493 7340. 0208 493 7340. If you're in Ghana, you can reach the Ghana office on 055 589 5959. 055 589 5959. And in all emergency situations, call the UK number 077 127 61884. 077 127 61884. BWF Solicitors definitely are trusted partners when it comes to the law. Now, BWF Solicitors helps us to bring you this live program, and we live on Facebook and YouTube at BWF Solicitors and at BWTV. BWF Solicitors and BWTV. A lot of people have had the chance of experiencing what kind of quality service that BWF Solicitors provides, and they send us reviews. If you have any feedback to give to BWF Solicitors, you can go on Google and look for BWF Solicitors and leave your review there. Or you can send us your review to our various social media platforms, TikTok, LinkedIn, Facebook, YouTube, and X. Of course, any network you think you can get on, leave us your comments there. And for this program, you can leave your comments in the second section down below, the comment section down below, so to speak, and at BWF Solicitors and BWTV. Victoria sends us this one, and Victoria is happy about what she has experienced with BWF Solicitors. She says, "My name is Victoria. I contacted BWF Solicitors to help me in my visa application. My visa came in less than a week, and I couldn't believe it. I'll choose them over any lawyers in the UK. Thanks to Helena, one of the members." Well, thank you very much, Victoria, for giving us this feedback, because obviously that's what BWF Solicitors does. They help you through all the legal journeys, whether it's immigration, nationality, business support, so to speak, business development, employment, and all the other bits. Talk to BWF Solicitors. Let me give you the address again. Fourth floor of the Anna House, 214-218 Tottenham High Road, Seven Sisters in North London. Call 0208 493 7340. 0208 493 7340. Or you can call the emergency number on 077 127 61884. 077 127 61884. BWF Solicitors definitely are trusted partners when it comes to the law. So, Victoria, thank you for doing that. And those of you who have any feedback to give us, both the constructive criticism, the praises, and of course, telling us how you experience their services, let us have that through our various media platforms. So, Victoria, thank you. Those of you who have joined us, I want to welcome you. As I said, we're live on Facebook and YouTube at BWF Solicitors and at BWTV. Now, let's see a few that we have and acknowledge them after the housekeeping. I'll give you the nugget. Ade Safo comes up and says, "Good afternoon, everyone. Thank you very much, Ade, for helping us do that." And he continues to say, "Share when you join us, because we would want other people to also enjoy what it is that we're enjoying." And if you come in and you are new here on the platform, click on the notification button and subscribe to the channel as well, so that whenever we put out content, you will be notified and you will join us. Tiliduma, you're watching with us. Thank you. We have, as Adesafu has said, he's put in the comment, John Zuta and Debogri. You're watching Mosu Ejike. Thank you, John, being a GM, Kobe Pop Fanos. I have Blinks B and a host of other people. Now, let me take you to BWF Solicitors, and when we come back, we will show you what they give us every week. That's the legal nugget. And then we'll get Lawyer Charles Asma to be on to explain that to us and then lead us into our discussion. I think stitch in time, so to speak, is what we are looking at, what to do to prepare for the new settlement rules in autumn. We'll be right back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Well, thank you very much for sticking around. We're so proud that we can bring you what it is that we do to make you feel comfortable and empowered to be on the right side of the law. And we'll do that with BWF Solicitors, our trusted partners when it comes to the law. And this afternoon, As I said, we have a resource person from the stables of BWF Solicitors, Lawyer Charles Asma, here with us on the show. Uncle Charles, good afternoon.
Good afternoon, Brakoku.
How are you doing, boss?
Very well. How are you too?
Well, I'm good. The sun is out, so I've worn something with the sun in, in my t-shirt just to enjoy it. And we thank God for life and everything. BWF Solicitors, we're grateful to you as well for giving us the opportunity to reach out to the community. And on a more positive note, one person has given us some positive feedback, which, having introduced you, I'll share with viewers as well and to you as well. Her name is Victoria, and Victoria says she contacted BWF solicitors to help her in her visa application. This came in less than a week, and she couldn't believe it. I believe that sometimes people think that the Home Office will go the whole 6 months, the minimum, or up to 6 months, they say, and sometimes even beyond. Some have been waiting for more than a year and all that. So for her to receive hers in a week, it was quite unbelievable. And she goes on to say that she would choose BWF solicitors over any lawyers in the UK, and saying particular thank you to Alina, one of the members. I know it makes you feel satisfied because the community is getting what you give them.
Yes, proudly so. And it's not surprising that there is another testimony. And as a matter of fact, every moment there is somebody celebrating success
Mm.
or feeling satisfied for encountering BWF success. We are community lawyers, and what we do is to bring smiles to the faces of members of the community.
Well, thank you very much. And as usual, we say thank you and come back for more. So this afternoon, we are coming back for more. And I'm starting off with the piece of information you put out earlier in the week. And it's talking about a family court case that doesn't automatically stop removal from the UK. And it says that the Court of Appeal has confirmed that ongoing family proceedings will not always delay immigration decisions or removal action. The court has made it clear that where there is limited contact with a child, weak evidence of a genuine parental relationship, or signs that proceedings were started mainly to delay immigration action, immigration proceedings can take priority. It is important, it goes on to say, to note that simply starting family court proceedings is not enough. Applicants must show a genuine and subsisting parental relationship, active involvement in the life of the child, and that the child's welfare genuinely requires their presence in the UK. This, as you said, is a major reminder for parents relying on Article 8 family life claims, especially in cases involving British children, contact disputes, or pending child arrangement proceedings. Early legal advice and strong evidence are now more important than ever. Obviously, we are looking at this based on the case of Ahmed versus the Secretary of State for Home Department 2026, England and Wales Court of Appeal case 509. What is the saying, lawyer?
Right. So before we even go into that, I want
Mhm.
us to contextualize it.
Okay.
Now, let's take it that I've always been coming to you for help. So that's the context. I've always been coming to you for help. For the past 1 year,
Hmm.
I've been coming to you for help, coming to you for help, coming to you for help. And yesterday, or just this morning, you called me to say that, hmm, no, the thing that you've been asking, I'm ready for you.
Hmm.
What will come into your mind potentially?
Um, I'm now kind of made up my mind to continue with the whole thing, isn't it?
That's one possibility. What else? All the possibilities.
Now I see that I'm in trouble. I'm in a tight corner, so I'm trying to hide behind something.
No, No, I'm the one calling you that I'm not ready for you.
Okay,
If,
so
so if needed help from me all this while,
all this while, why haven't you said it?
yes, and all of a sudden you say, okay, I'm ready. After 1 year, I'm ready to help you. What will come into my mind that okay, he's ready to help me? Ideally, as you said, you say, okay, he's ready to help me because now he's ready, right?
Mm-hmm. Yes, I
But
did.
I knew you could help. That's a contest. I knew you could
I
help.
knew you could help, but you were
Right.
delaying.
After 1 year, you've come to say,
So what's
okay,
the reason? Is there any ulterior motive behind it?
a lot of things, isn't it? Could
Yeah.
be that, oh, does it mean that he needs something from me? So he wants to help me quickly so that he can come
You
for
can
his.
get that benefit. Yeah.
Or what is going on? So many things, isn't it? Right. What is the difference here? It is the timing that will make you think like
Okay.
that. It's the
Mm-hmm.
timing that will make the difference.
Mm-hmm.
Ordinarily, there wouldn't be any big deal about you ask me for help and I deal with it few days or weeks later. But timing, and that
Mm-hmm.
will make me wonder, or maybe when the person realizes that I'm also able to do it for myself, will then say, oh, ready for you, but now I don't need it. So a lot of things could be the reason why this person would delay and do it like till at the last minute, right?
Yeah.
Now let's go to the nugget, and I will tell you why I gave that context or
Okay.
analogy.
Yeah. So then it's saying that the Court of Appeal has kind of confirmed that ongoing family proceedings will not always delay immigration decisions. And it goes on to say in the second paragraph, the court has made it clear that where there's limited contact with a child, weak evidence of a genuine parental relationship, or signs that proceedings were started mainly to delay immigration action, immigration proceedings can take priority. The next
So
paragraph goes on to say
yeah,
it is
continue.
important to note that simply starting family court proceedings is not enough. Applicants must show a genuine and subsisting parental relationship, active involvement in the child's life, and that the child's welfare genuinely requires their presence in the UK. This
So
is a major
yes.
reminder for parents relying on Article 8 family life claims, especially in cases involving British children, contact disputes, or pending child arrangement proceedings. And it goes on to give the advice that early legal advice and strong evidence are now more important than ever.
Right. So early legal advice. In other words, if you want to do something, you must do it in time.
Mhm.
And this is again equitable principle. One of the maxims of equity is that it says equity favors the wise, not the foolish.
Mhm.
Number two, equity equity expects you to act in time.
Okay.
So if you don't act in time, it defeats the purpose of what you are trying to achieve.
Right.
This is somebody who says that I have a child. The person knows that they have a child, and there's all this while for 1 year, for 2 years, for 5 years, for 10 years, they've not boarded. And they decide to go for their immigration application. They want to stay in the UK. They put in application or they go for access to the child to be able to apply for what they want. Question: is this person seeking to look after the child because the person wants to look after the child? Or is seeking to look after the child because he needs to look after the child to be able to benefit from looking after the child? It's
It
more.
could be either way. One way, if they are genuine, fine. The other way, because they have lost time and they are on the verge of being asked to leave the country, then they find a loophole and say, oh, okay, if I'm looking after this child, it may allow me to stay on. So then let me follow that.
And again, that's the beginning of the whole conversation where I gave a context that if you delay what you ought to do, we'll be wondering, why are you doing it now? What could be your motive at this
Okay.
stage?
All right.
So where the person is facing removal or risking overstaying or facing immigration related challenges,
Mhm.
they decide to resort to family law opportunity.
That's right.
Such opportunity could have been sought long time ago, but they decided not to seek it, only to go for it to be able to get out of this trouble. They will tell you that you want this not because you have to, you want this because of your personal gain.
Okay.
And on that basis, immigration risk will prevail over family law advantage.
Right.
So the court, in the case of Ahmed and the Secretary of State 2026, the court ruled that yes, you are seeking child arrangement order to look after your child, but that is last minute. It's afterthought when you realize that you are at risk of being deported or removed from the UK. And therefore, if you claim that you have an appeal pending, and so you cannot, for example, go back to your country and participate in the appeal, we won't let you take advantage of the immigration. You have a child arrangement order pending, and you say that you can't take me away because I have a court hearing for family court proceedings. Ordinarily, if you have court proceedings, we'll have to let you stay and participate. But we realize that this court proceedings is just there for your own good, not the child's good. And so we'll tell you, go to your country and participate remotely. Because immigration,
In that case, sorry to interrupt. In that case, if you go to your country and you participate remotely, if it goes in your favor, would you be given the opportunity to travel back to the UK to continue with that family life relationship you have with a child?
but if it's about family life relationship, what do parents do? You offer financial support, right?
Hmm.
And if there's another parent or somebody else, the person will offer physical support.
Yeah.
So the person who is being sent away, if they so care, then they can send the money through the other parent to look after the child. They can do WhatsApp videos every minute to see the child. They can talk to the child. They can do everything they want to do remotely.
Hmm.
After all, they said that they are going to court for the arrangement order for the child, not for themselves. So you don't have to come back to the UK to be able to do what you want to do.
Yeah.
And so, where there is conflict between immigration law and family law, depending on the timing, immigration law duty will prevail upon family law right.
Okay. Well, early legal advice and strong evidence are now more important than ever. This is on the or based on the case Ahmed and Secretary of State for Home Department 2026, England and Wales Court of Appeal case 509. Well, then I let me put the scenario out and see what it is that we can have to do in this situation. Balibo and Ade had a baby, Aki, in 2023. Balibo was a student whilst Ade was a British citizen. Ade successfully applied for a British passport for Aki. For over 2 years, Balibo did not show interest in the care of and support for Aki. In 2025, Balibo's post-study work visa application was refused and he eventually became an overstayer. Fearing deportation, he applied for leave to remain as a parent of Akib, who is, one would say, a qualifying child or a British child. His application was refused. He then appealed against the refusal and also made an application for a child arrangement order for him to have access to Akib. He believes that he cannot be removed from the UK because he has a pending family court case about the care of this young person, Aki. So, what advice would I be able to give Balebo? Would it be that a pending child arrangement case will not stop his removal from the UK? Can I tell him that the pending child arrangement case will stop his removal from the UK? Or none of the two I've said earlier on or will be applicable? You know what? Let me leave this with viewers and see what advice they will give. Then later on, I'll come back to you for us to unpick this and see which answer will be correct. Would that be okay?
Sure.
Okay. All right. Well, thank you very much, lawyer. So, in that case, let me say once again, thank you to BWF Solicitors, our trusted partners when it comes to the law, for giving us this opportunity to come your way with the community and the law. We're going to test our knowledge based on the nugget and explanation we have received, and also delve into that discussion that starts with one of my favorite quotes: a stitch in time saves nine. What to do in preparation for the new settlement rules that will come in autumn 2026. We'll be right back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Well, welcome back and thank you very much. Lawyer Charles Asma from BWF Solicitors is here. Remember, after the discussion, the phone lines will be active and it will be 0208 493 7345. 0208 493 7345. Or you can send a text, WhatsApp, and a voice note to 07399 208 468. 07399 208 468. Lasma, you have picked up one of my favorite quotes. A stitch in time saves nine. Something is coming and we're having a preview into that for autumn 2026. I believe it's something that's going to have an impact on so many people, especially if we're looking at applying for settlement here in the UK. So I will open it up in front of you and help us unpick that. A stitch in time, what to do to prepare for the announcement for settlement in autumn 2026. What's coming?
Thank you very much. So, viewers and listeners, once again, good afternoon. We know that the government has declared intention to ensure that yet, all those who are yet to apply for indefinite leave to remain, apart from certain categories of people, will have to go through some military process. I've used the word military process because you have to meet certain fitness criteria to be able to apply for your indefinite leave to remain. And it is this that we'll be looking at. Question is, when is autumn? Autumn is going to be September, October, November. So that's autumn. And so give and take, talking about 4 or 5 months time, we'll know what the government actually is going to start doing. But we have an idea because the government has already told us that this is what's going to happen, but it's going to be delayed until late year, which is autumn, either September, either October, either November 2026, before winter. Now, what are some of the things the government plans to do? Who is affected and who is not affected? Those who are not affected don't have to bother, but those who are affected will have to then know what to do so that they can stitch it in time to avoid whatever consequence that this provision or this program will pose to them. Now, we know that up until today, if you are applying for indefinite leave to remain, it's a simple exercise of taking the time, what we call counting time. So you count 1, 2, 3, 4, 5, 5 years, I qualify for indefinite. Or you count your time 1, 2, 3, 4, 5, 6, 7, 10 years, I qualify, isn't it?
Yeah.
That is
That's what we know.
That's what we know. But all of a sudden, government is saying that no, it's not just going to be you counting your years. It's going to be more than just your time. Because some people might have spent time in the UK, but they are useless to the country. And some people would have also spent less time in the UK, but very useful to the country. So those people who are not so useful will be punished or will be delayed opportunity to settle. Because once you settle, you have reached the bar. Once you settle, you don't have any immigration control anymore.
Okay.
And so it's not a case of anybody to settle, but those who must settle will be encouraged to settle. And so settlement is not going to be time spent as usual, but the government is saying that it's going to be earned. It's going to be on merit basis.
Okay.
And that is called earned settlement regime. Earned settlement. So how do you earn it? So that if you know this way, you have to do.
That what we know as indefinite leave to remain will change to earned settlement regime?
Well, what we know to be counting time.
Okay.
For indefinite, counting time towards your indefinite. As I said, 5 years, you count 1, 2, 3, 5 years, you apply for indefinite. If you are on the 10-year route, after 10 years, you move to indefinite. Isn't it? That's what we know. And that is the long residence regime.
Okay.
Long residence regime. So that's the era. That's where we are. But that era will change, or regime will change, where you don't just tell us how long you've been in the UK legally, but you tell us how useful you've been in the UK whilst you've been in the UK. And so to be able to do that, you have to show certain signs of usefulness. And if you're able to demonstrate usefulness, we'll tell you that indeed you've earned your right to settle. If you are not able to demonstrate signs of usefulness, they will tell you that you haven't earned your right to settle, so you can't settle yet. And so some people, it will take them a longer time to settle, some it will take them shorter time to settle because you have to earn it. And so the more points you have, the easier it is, or the faster it will take you to settle. So with this end settlement that the government is introducing in autumn 2026, what is the government saying? Who will be affected? Who will not be affected? And those who are going to be affected, what can they do or start thinking of doing so that they stitch it in time, so that they know what to do once the program starts? So we are all preparing ourselves for what is coming, and not just preparing by way of information, preparing by way of what active steps you can take so that you know how to shorten your time to indefinite. Or maybe there are certain things you don't have to do if you don't want to risk staying longer before indefinite.
Okay. Now,
So
let me also get this clarified. So between now and autumn 2026, it means that the standard, if I should put it, what we know, where we can count 1, 2, 3, 4, 5, and we qualify for indefinite, or 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, or any other criteria or threshold, then we reach the point where we can apply for indefinite, is going to change. We are in the period of kind of getting ready for a new regime. So if you have anything, you do that before the new regime kicks in, right?
yes.
Okay. All right. So I will reiterate the advice BWF Solicited gives us all the time, that if you have anything to do it quickly and now. If you can do it quickly and now. Contact BWF Solicited. They can support you with that. Call them on 0208 493 7340, 0208 493 7340. If you have anything to do it now and quickly, because equity favors the wise, I should say, but don't delay, so that you have to go through several other routes and remedies that might cost you time, might cost you a lot of money, and might not even work for you. Well, let's go on.
Thank you. And I like your last bit. Delay defeats equity.
Mhm.
So if you delay it, you may end up risking it. So what is it that the government has planned to do,
Okay.
and who will be affected directly and who will not be affected? Those who will not be affected do not have to bother. They can live their life as if there's no tomorrow. Those who are going to be affected will have to think twice before they live life. Otherwise, there will be tomorrow. And so these are the conversations for this afternoon. Now, producer is going to help us with what the government has intended to do. Then from there, we'll look at those who will be affected and what can be done to mitigate that by way of stitching it in time.
Mm.
So, producer, if you start from the top for us, so move to the top. Okay, excellent. Keep going, keep going, keep going, keep going. Fantastic. Okay, Brakoku, you are going to take us through that.
So yes, it says, as you find on your screen, the resource, 20th November 2025, UK legal migration changes. And it says settlement route. Number one is top rate tax, years to settle, 3 years. So if you pay top rate tax, well, lawyer will explain that. So let me just run and whisk through that quickly. Global talent, 3 years. And for all that, the conditions are clean criminal record, speak English to A level standard, so to speak, sustained national insurance contribution, and have no debt in the UK. Now, top rate tax, global talent, 3 years, British
So,
partner, 5 years.
so Brakoku, we're going to take them in turns. But before that, let's look at the conditions that affect everybody.
Mhm.
The standard conditions that
Clean
one
criminal
affects
record.
everybody. So, if you haven't had indefinite leave to remain already, you are planning to get one in future, make sure that you don't get into trouble that will lead to criminal record.
Okay.
Because one
Then
of the
speak English
conditions,
to A-level standard.
you have to speak English to A-level standard. So we'll come to that and look at what can people do. And we'll be looking at this, what can you do? This, what can you do? So the next one is that the government is introducing sustained national insurance contribution. So if you don't contribute, you don't chop.
Okay. You can't put your hand in a pot.
You can't. You can't. It's a forbidden pot. Only those who are a royal family can dip in. Here, only those who have been circumcised can put their hand in the
Can put their
pot.
hands in the pot.
Yes.
Then there's this last one that says have no debt in the UK. Now, if you talk about debt, people have credit cards, people have loans, and several others, several other forms of borrowing. Does it mean that if you are not settled, you can't have these?
Right. What it means is that for the debt in the UK, debt is going to be something that the government will be using to assess whether somebody should be allowed to stay permanently in the UK or not. And here we are not, before we knew that if you owe the government, i.e., health, tax, court, these are, or even home office, these are government debts. But now they are saying that no debt, and they didn't define it. I'm sure the law, once it is finally adopted, will tell us what debt they are looking at. But for us, at this stage, we know that debt is debt. And debt here, we are looking at protected debt or secured debt. So such secured debt could be mortgage, could be personal bank loans, credit card loans, and so on and so forth. And so with these ones, whether secured or unsecured, if the government is able to track it, then it can be used against you.
Now,
It's a matter
if I
of
have
having a
if I have a mortgage, which is a form of debt, it's an amount of money that has been lent by a bank, so I can uh, develop equity into a property for it to eventually become mine. If that is what it is, and you are not going to allow me to settle, then it means that I can lose my um, my property investment.
So
Potentially.
here, every day people borrow money.
Mhm.
When you borrow money, what do we expect of you?
To pay back.
So if you are paying back, are you wrong?
Yeah, but this one says vaguely,
You are
have
not
no
wrong.
debt.
You say you have no debt.
Mhm.
And so we are trying to define what do they mean by no debt.
Mhm.
If you borrow money through whichever means and you are paying back, that is what responsible people do.
Yeah.
If you borrow and you don't pay or you abandon it, then
Mhm.
it becomes an albatross, right?
Around your neck, yeah.
Exactly. So that is debt, pure debt.
Okay.
So a debt that is being serviced is normal debt. But a debt that is abandoned,
Okay.
we have to trace to the person who abandoned it and punish the person through
Punish the
this
person.
through this end settlement program.
Okay.
All right.
Right. So
So these
let's
are the
let's look at the various categories and the years to settlement. Then you take us through what it means, especially with the years to settle, if that's okay.
okay. So maybe because we are looking at what to do with the conditions. What should people do for conditions? People must make sure that they don't get criminal record
Mm-hmm.
before they are indefinite. Otherwise, it will go against them.
Yeah.
People must make sure that they speak English up to the right level, which is B2 or A level. So if you are not there yet, start preparing yourself. Sit the exams. Keep practicing, keep trying until you get your B2 before your indefinite is due to be.
English to A level standard. Is it not what we use on the train, in the barber shop, in the restaurant, and basically our work? Or it's more than that?
Well, that is functional skills, but we have different levels of functionality.
Mm-hmm.
So, what we are doing, we are applying our literacy skills, aren't we?
Yeah.
We are speaking and we are listening. At the same time, we are reading because there's something on the board we are reading.
We are reading, yes.
We read to understand. So if we read and we are not able to understand to apply it, then there's no functionality.
Okay.
And so the proficiency level is higher at some point.
Okay.
Because the information we are reading, to be able to interpret, we have to understand it deeply to interpret it.
Yeah.
And so the appreciation of literacy is higher as we go up the ladder. So A level, we have A, we have B, we have C. So the English at A1, A2 is basic English. At B1 is secondary school level,
Mm-hmm.
and B2 is college level.
Okay.
College level, they write English language and English literature.
Yeah.
And the language, we have foundation language and higher level, right? Higher language.
Yeah.
And so a B2 or A level English, you'll be looking at higher English, not basic English. So ability to comprehend, ability to write, ability to understand. So it's not just going to be me go, me come, but me go, me come, and you extend it to proficiency. I am going to school because I have enrolled to do a course that will run for 2 years, and for that period, I will be studying. That is higher level.
That is going to be a big wahala.
But that is what the government intends to do. What it means is that if you are going to if you are going to apply for indefinite and you can't function at that level, you can't
You can't.
apply. You just have to keep doing your taught, 2.5, 2.5.
Well,
Right. So the preparation is for people to get started now, so that you practice, you keep practicing. By the time you are ready for your indefinite, you would have passed your B2. It's doable.
okay.
The next one is that you have to work and pay national insurance.
Yeah.
Who pays national insurance, Brakweku?
Everybody that earns a salary above a threshold
But how will you earn a salary?
by working.
So who pays national insurance?
Every
Those
worker.
who work. Those who work, isn't it?
Those who work, yes.
So if I don't work and I don't pay national insurance, that means I cannot apply for indefinite.
Yeah, because you're not being of benefit to the community. You're not contributing to the pot.
So what's going to happen is that they are going to reward busy hands and punish idle hands.
Mm-hmm.
So if you are not working, you continue to enjoy your 2.5, but you can never have to do your indefinite because you are not contributing anything. So you are useless, literally.
You're
You are
not
not
benefit to the
you are
community.
not useful enough. You are not adding value.
Mm-hmm.
And so if you are paying your national insurance, you are contributing to national insurance, then we see you to be adding value. And so you can earn citizenship. Earn settlement.
Okay.
Right. So one way of doing that is to find a job, start earning, so that you can contribute and contribute more. The more you contribute, the faster it will be for you to get to indefinite.
Okay.
So that is
So then we can summarize to say you must be useful by working. You must be functional in the community by speaking English to A-level standard. You do not have to ignore any debt that you have contracted. Be a responsible citizen by paying back what you have borrowed so that people will know that you do not want to take advantage of the system. And then stay away from trouble. Don't ever get a criminal record. These conditions must be met by everybody who hasn't had settlement yet.
fantastic. except those who are exempted. We'll come to the exempted categories.
Okay. Well, I think that we are giving a lot of information, and I want Lawyer Charles Asma to sip some water. Also, relax, because we're going to some fine details, and you are going to get out some numbers into your system. So we'll take this short break. Say thank you to BWF Solicitors. When we come back, we're looking at some more specific details. A stitch in time, they're saying, saves now and do that before autumn 2026. We'll be right back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
The UK government says that the route to settlement will be guided by certain principles in autumn 2026, and the rules are going to kick in. And we're looking forward to that period, and we're looking at what people who have not settled here in the UK can do to meet those requirements as will be set out in the rules. And we're doing this on the program, The Community and the Law, and it's brought to you by BWF Solicitors. Our resource person this afternoon is Lawyer Charles Asma from the stables of BWF Solicitors. Abnadazi Promise Blinks B, Weedy Castro, Yawin Team, Gideon Esuman, Felix Fidelis, Augustine Akanyame, Julie D. Ansu, Tiliduma, and all those who are watching with us. I will say thank you very much and welcome on board. If you haven't made your presence felt in the comment section down below, please do that. And if you have a question to put to Lawyer Charles Asma, he is open to pick them up after our discussion. So get ready. Text that to 07399208468. Or when the lines are active, you can call us on 0208 493 7345, or you can leave that in the comment section below, as I mentioned earlier on, and we'll pick them up. Last month, yes, we're looking at settlement, the new rules that will come in autumn 2026. We've looked at the general conditions that affect everybody with the exception of those who are classified to be exempted. Now let's look at some fine details, as you mentioned.
Yes, so those who are not affected by what the government intends to introduce are EU nationals and their family members.
Mm-hmm.
So if you are EU national waiting to apply for your settled status, this is not for you. You are exempted.
Okay.
If you are a family member of an EU national on 5-year pre-settled waiting for your settled status, this does not apply to you. You are exempted. If you are a spouse of a British citizen, you are on 2.5. You are waiting for your second 2.5 and you go for your indefinite. Or you are already on your second 2.5 and you'll be going for your indefinite after autumn or next year. It doesn't apply to you. You are exempted. You are a parent of a British child and you are on a 5-year route, or you are on a 10-year route, parent of a British citizen on a 5-year route or on a 10-year route, this does not apply to you. What about those who are on a 5-year route, but their spouses had indefinite leave to remain, and on that basis, they were able to apply to remain under Appendix FN? For now, it's not quite clear what they will do. I want to believe that those whose spouses had indefinite leave to remain and they were given 2.5 will be treated the same way as those whose spouses were British citizens. Because if your wife or husband is a British citizen and you are given 2.5, and your wife or husband has indefinite and you are given 2.5, why should you be treated differently once a new law has been introduced? So I just want to believe. However, please, let's wait and see what the treatment will be for those whose spouses had indefinite, and on that basis, they were granted 2.5 under the 5-year route. Okay, now we go into the key details. Those who are on 2.5, those who came as visitors, those who entered the UK illegally, those who came to seek asylum, those who came as skilled workers, those who came as students, whatever category you came under, you have your bit specified. So we are going to go into the specifics to see those who can gain and those who will lose. And so we'll have to wait a little longer, and what they can do to fast track it or to reduce the time.
Okay.
Yes. So producer
So
will
I
need
think
you.
we will go back to that resource that we're looking at earlier on and look at some fine details. It's not a community in the law, and remember, it's brought to you by BWF Solicitors, our trusted partners when it comes to the law. So we will go to the serial numbers and look at the settlement route and years to settlement. Well, with your permission, I'll start with number one, which is the top rate of tax. And years to settle, they say 3 years. Now, when we talk about top rate of tax, what category of people are we looking at who pay that top rate?
So yes, we are looking at those who earn 50,000 plus a year, 50,000 plus a year,
Mhm.
and those who earn £125,000 a year.
Okay.
So if you earn £125,000 a year, you are super high rate earner. And if you earn 50,000 and above, or £51,000 a year, you are a high rate earner. Those people will be able to complete within 3 years.
Right.
So those who are 125, who are earning 125 a year, can finish within 3 years, and those earning 50,000 a year can finish within 5 years. And these are skilled workers. Should we say highly skilled workers?
Okay.
Because everybody is a skilled worker. So we have to differentiate. Highly skilled workers can finish within 3 years and 5 years, depending on how much they earn and how much tax they pay and how much national insurance they pay.
Yeah.
And again, the tax payment shouldn't just be one, it has to be 3 consecutive years leading
Okay.
to your application. 3 consecutive years. So if somebody has had his or her salary increased and they jump into 51,000 a year, but before the 51,000 they were on, let's say, 49,000, and they've been, once they got into the 51,000, they've had it for 1 year, then they need to stay for 2 more years on the 51,000, for example. Then those on 125,000 a year, again, they have to pay tax on that, but they should have had that salary for 3 consecutive years to be able to finish their race within 3 years.
Okay. Then the next one says global talent. That looks like a broad something. When we say global talent, what are we looking
Right. I always say that somebody who is globally talented has a skill, knowledge, or something so unique that the benefit of that skill helps the whole world, global.
at?
And you can say that global talent is not the basic professions that everybody is into.
Okay.
We are looking at something that is revolutionary, something that cut across. So it can be IT, it can be aviation, it can be engineering, it can be something special. But what is special? Again, whatever is global talent in nature must be confirmed by a body that can assess and say that, yes, this talent cuts across. And therefore, if it is Britain, you can be used in Britain through trading abroad and benefit Britain. So that skill can be used in Britain and will benefit Britain through its export or associations or partnership with other countries. So if it is IT and you have such special IT skill, through that IT skill that you are applying in the UK will benefit trading abroad, for example, and so on and so forth. That is how we put it. But to get that visa, you've got to follow a process. And again, those people can finish their race within 3 years.
Okay. And
Then,
it says British partner. That's 5 years. It looks like that has not had any change proposed to it.
exactly. So we said that those ones are not affected.
Okay. But then
So,
I have a bit
sorry,
of a
once we
question.
are at this, what we'll do is that let's just add the what to do quickly so that we don't come back to what to do's.
Yeah. But if you would just permit me, let me look at
Mm,
number 4 and number 1. Now we're
okay.
saying top rate of tax and high rate of tax. Um, is there a range that we are looking at? Because the high rate says 5 and the top rate says 3. Um, the standard I know in the UK is 20%, and beyond the threshold, you move to between 45 and 50%. Can you clarify that for me, if you may?
Sure. And I think I did earlier on, but I'm going to repeat.
Hmm.
So I said that the top rate people will be those earning 125,000 a year.
Okay.
And the high rate are the people earning 51,000 a year.
Okay.
So those earning 51,000 a year, they can finish within 5 years. And that earning should have been 3 years consecutively up to the
Consecutive
date of
3 years.
session.
Okay. All
And
right.
those earning super rate or the top rate will be those earning 125,000, and you have to earn it consecutively for 3 years up to the date of your indefinite leave to remain application.
All right. Yeah, Laura mentioned and proposed that we go to what to do to meet these, either to make it come quicker for you or to meet it as it is. And if you see on the screen, the number of years and the various settlement routes are outlined there. For the purposes of time, we will be looking at what a lawyer has proposed. So, yes, what do we do with the ones that have changed? Can we do anything to bring them forward or arrive at them earlier?
Okay, so let's assume that you are currently earning 40,000
Mhm.
and you want to fast track your time. 40,000 is not up to the range. So what is the best thing you can do? Upskill yourself, apply for higher jobs and earn 51,000 a year or 125,000 a year if you can. So that
Mhm.
is what. Again, you can apply for global talent visa, and if you get it, you are able to fast track your time. Then we move on to British partners. You are not affected. And so if you want to apply, if you want to finish your race quickly, then your spouse should be a British spouse, not skilled worker spouse, for example.
Okay.
Right. Then we move on to the next one. Producer, what do we
Can
have there?
we put the resource back on for easy reference? Thank you. So we're talking about the Windrush and EU settlement scheme. You have made it clear that we don't have any change to that. British overseas nationals from Hong Kong, that's
If you go
5
to five,
years.
go to number five.
Yes. So number 5 says public service, including doctors, teachers, and nurses.
Yes. So producer, if you can put me somewhere so that the public can
Yeah.
see me.
Can we have lawyer on the left? Well, yes, you're on the screen. You can
Thank
swap
you.
it. It's
Yes.
fine.
It doesn't matter. Yeah. So yeah. So here, we are saying that there are some people whose skill set is beneficial to the public, and we call them public service workers.
Hmm.
So with those offering public service, examples would be doctors. So if you're a doctor, you are likely to finish within 5 years.
Yeah.
If you're a teacher, you are likely to finish within 5 years. And these are skilled workers, remember. If you're a nurse, so if you're a skilled worker nurse, you can finish within 5 years.
Hmm.
So what will be the learning here? If you want to fast track, then you may have to convert from care worker to nurse or to teacher so that you'll be able to have the
I
protection.
see that you have highlighted 11, which would
We'll
be
come to that.
15 years.
We'll get to that. Yeah, we'll
Yeah.
get to that.
Now, I highlighted that because you were advising people if you are in the healthcare industry, you
Oh,
want to
right. That's a good
move
one.
up from where you have to go 15 years to where it will reduce to 5.
Yes. Branko, a lot of people who are care workers in the UK
Mhm.
have nursing qualifications
From their home countries.
from their home country. And what you do is to standardize that.
Mhm.
And the standardization process is to do with doing what we call the CBT course.
Mhm.
And the nurses will have to do that conversion course.
Okay.
Just like if you're a lawyer, you do a conversion course. If you're a doctor, you do a conversion course. If you're a nurse, you do a conversion course. And once you've done that conversion course in the UK, you have the certificate and the license to practice as a nurse in the UK. So
Okay.
imagine you are working as a care worker in your hospital, and you have nursing qualification from abroad. So you've gone through the process to standardize your overseas nursing qualification,
Mhm.
and your hospital now knows that you've got your PIN to practice in the UK, and they give you a job. This time not as a carer but as a nurse. Then you'll be able to fast track it from potential 15 years to 5 years.
Right.
with now sponsorship as a nurse.
Mm-hmm.
So that is a way to get around that based on if you have nursing qualification. Again, somebody might have come as a with teaching qualification, but they are doing care. You go through the process to regularize. You can do what we call petals. Petals is preparation to teach. We have CETOS, certificate to teach, and we have DETOS, diploma in teaching. So if you are diligent enough and you go through that, because maybe you have UCC degree, you have Univa degree, you have some teaching qualification from abroad, and you standardize it, you do a bit on top in the UK to add to that, upskill yourself, you have teaching job, you apply and you are employed. Because teaching is part of the public service roles, you can fast track it to 5 years.
Okay.
So these are house.
Right.
Now we go to the next one, Ragoku. So you take us.
The next one, well, the number 6 says is unchanged, so we will skip that to number 7. That is British overseas nationals from Hong Kong. That's specific, so we can skip that. Now 8 says volunteers, 5 to 7 years. Who is classified as a volunteer?
A volunteer is somebody who uses their time, their knowledge, their experience, and skill for the
Mhm.
benefit or put those things, make them available. They make those things available for the benefit of the community, free of charge.
Mhm.
So, one way of cutting down your time to indefinite is to freely offer what you have. And where do you offer? You offer them at where they are needed.
Okay.
So your spare time, you can go to your local hospital and volunteer to do anything at all. You can go to your local charity organization that you recognize to help them.
Mhm.
You can go to your local church to help. Somebody will say, which church? Is it the normal one-man churches or the normal two-man churches or the normal Church of England?
Maybe you say a church that has a board and recognized by the Church of England, maybe.
So so at the moment it's vague as to which churches will qualify to allow people to volunteer.
Mhm.
Because all those churches, when people volunteer, they have to record their time, just like timesheets.
Okay.
And once you have enough points, you convert it to reduction of your time. And that's why they are saying that those who volunteer can finish within 5 years or 7 years. What it means is that the more you volunteer, the more credit you get or score.
Okay.
So, how many hours will be defined once the law comes? But
Mhm.
for churches, what they will do is to define those particular churches, maybe churches that are accredited to to regulate in the UK
Okay.
or to perform in the UK. So if your church is not regulated, then that church may not qualify as grounds for volunteerism.
So could if a church, for instance, is registered as a charity and recognized within the community, would they, or we may have to wait for the law, would they be qualified as offering uh, opportunities for volunteering?
So if the church is recognized, once the law comes, they would identify which churches will qualify. Once your church qualifies, then your church leader, pastor, religious minister, or whoever will be able to confirm that you've done enough hours of voluntary work.
Mhm.
Imagine our type of churches. How many of them will freely give our credit? So they will be clear which ones will qualify. But that
Okay.
is why we are not sure how they will define that. So we don't
Okay.
want to preempt that every church will, but churches will.
Well, so moving on, we have the English
Oh,
language.
and one, sorry, one other area you can volunteer is your local school.
Okay.
You can volunteer as a dinner lady or dinner man. You can volunteer at playground support worker. You can volunteer as trips and visit support staff, all these things you can volunteer in, and the school will give you the certificate of credit.
Well, thank you very much for that clarification and extra information. Speak English to degree level standard, which is number 9. And that in itself is in the general conditions. How do the two marry?
So B2 is A level
Mhm.
and C1 is degree level. So if we say the B2 is hard, then C1 is harder.
Okay.
So if you're
And
able
that
to
says 9
apply,
years.
yeah, that one will give you 1 year credit. It will reduce it to 9 years.
Okay. All right.
Imagine you are on a 10-year route visa and you've been able to show English language proficiency, you've done the exam, and you've got C level, then that one will give you 1 year credit. So
Okay.
instead of waiting for 10 years, you only do it, apply for indefinite after 9 years.
Now we're getting into the higher numbers, interestingly. New baseline arrived on safe and legal route, 10 years. Safe and legal route. What's that?
Okay, yeah, let's look at those who arrived not through safe and legal route. What are illegal routes?
Stowaway,
Ways on the
those who
boat,
crossed
under the
the
boat,
channels on illegal boats and all that.
right? Yes. So those who came, so now if we say somebody arrived safely and legally, how would they have come?
Through the airports, the
Airport,
recognized entry routes.
exactly, recognized entry route. They are checked and they are permitted to enter. So
So,
those people are legitimate entrants.
so if I arrived as a visitor, that obviously is a question. I arrived through a recognized airport with a recognized airline. Can I say that when I stay for 10 years, I can qualify for settlement?
So the question is, what was the intent of
Okay.
that arrival?
Hmm.
If you arrived to visit, then there's no presumption that after 10 years you qualify to stay. Because your arrival as a visitor, even though legitimate, is not one of the legal routes to come and settle in the UK.
Okay.
So what are the legal routes to settle in the UK? Work-based routes.
Then
General
familiar relationships?
familiar relationship and so on and so forth. But those familiar relationships would have had their own defined
Defined
kind
time
of
to
right.
arrive at
Exactly.
settlement.
Yeah.
Okay.
So let's leave number 10 to be the baseline for most of these conversations
Okay.
and jump to 11.
Arrival entered on post-Brexit health and social care visas. I think we mentioned that earlier, didn't
Yeah. So this one will take about 50% of the conversation, isn't it?
we? Yeah.
Because a lot of them are found in this category. They arrived safely, they arrived legally, but they arrived specifically to meet COVID mitigating measures.
Yeah.
One of the post-COVID mitigating measures was to bring foreigners who have the right skill to help resuscitate the care sector.
Okay.
And for those people, they were told that after 5 years, they will apply for indefinite. And now the government is saying that no, 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 you can't have after 5 years. So it's going to change. But again, there will be different categories. So the 15 is also in layers. Some will finish within 10 years, some will finish within 15 years. Even though the standard is 5, if everybody will be moved to 10, and that takes you to number 10. So number 10 says that arrive safely and legally 10 years, isn't it?
Yeah.
And number 11 says that you can also have 5 more years. So what's the difference? Those who are on the care visas, We have lower level, medium level, and higher level in terms of skill set. You've heard that we have care workers and senior care workers, right?
Yeah.
What's the difference between a worker and a senior worker?
A bit more experienced and better qualified.
Exactly, and the salary is also higher.
His salary is higher.
So,
So
so
that could
for
push you into the higher rate of tax, isn't it?
not even the high rate of tax, but in terms of you maybe paying tax, or let's assume that you earn 20,000, 21,000, 22,000. Most of the care workers earn about 23, 22, 25. That is basic salary, standard. Such a person will have to wait 15 years for indefinite.
Okay.
Somebody will be earning 30,000, 40,000 as a care worker. Such a person will be medium. They may finish within 10 years, for example. Some will be earning 40,000, 45,000, but not up to 50,000 or 51. Those ones can also finish early within 10 years. So under the skilled worker route or care workers, if you are on a salary that is up to 40,000, then it will take you about 15 years. If you're on a salary more than 40,000, that will take you 10 years.
Okay.
Yeah.
Well, ladies and gentlemen, if you just joined us, we're looking at the settlement route and the years to settle. These will kick in during autumn 2026. And we're saying that a stitch in time saves nine. What to do to prepare for that set of rules that will be coming. And Lawyer has been giving us all the things that we need to know. I believe you may have a question or two. Put that in the comment section down below, either on Facebook or YouTube at BWF Solicitors and at BW TV. You can text that to 07399208468. Or when the lines are active, which will be pretty soon, we will allow you to call us on 0208 493 7345. Yeah, let's look at some very interesting points. I think between 12 and 14, where we're looking at benefits. People who would have collected one benefit or more, people who would have put their hands into the forbidden pot. Are they affected in any way?
Right. So number 12, what does it say? Benefit recipient or claimant. And they have claimed it for how long?
Less than 12 months. Less than
What
1
is
year.
less than 12? What is less than 12 months? In what could it be? What's the minimum month it could be?
So the
1 month.
1 month up to
So if
11,
you are up to 12 months,
12
or no,
months,
up to
yeah.
11 months. So if you say that, oh my God, I got it only for 1 month, that's fine. You've taken it.
Yeah,
And now you have to wait for how long?
15 years.
15 years, because you have just touched the untouchable.
You have eaten the forbidden fruit.
You've eaten the forbidden food, and the consequence is dire. You have to regrow.
And I've received it for a year and beyond. 20 years.
That one is even dire. You have to regrow longer. 20 years.
And it should be 20 consecutive years. You can't
Well,
add certain
your,
things.
remember your standard was going to be, imagine somebody who has been claiming for 5 years already or 2 years already.
Mm-hmm.
And today we are telling them that this is what's going to happen. Whether you stop or you don't stop, it is there to haunt you anyway. You've taken it.
You've taken
And they
it.
say it's going to be applied retrospectively.
Okay.
So somebody came to me and said, Lawyer, so in that case, what will I do? I said, but you've already taken it. So you might as well enjoy it. You've already sinned. Continue to sin. Because whether you repent or you don't repent, they will punish you.
Well, for the sake of time, let me ask this. Those of you who are watching us, we could give you the benefit of this resource. We can send it to you by WhatsApp or Maybe we'll pin it in the comment section so you can download it and keep. But is there a way where some of these shorter routes could be combined for me to reduce, for instance, my 15 years to about 5? We're looking at number 8. It says when you volunteer, it could take you up to 7 years, between 5 and 7 years. Global talent, 3 years. British partner, the 5 years. High rate of tax, 5 years, and all the rest of it, and particularly 5 as well. If, for instance, I am in number 12 and I'm able to achieve the number 5 status, for instance, would I reduce my 15 years or 20 years to 5?
So each category is standalone, and the fact therein would determine the benefit for that person.
Mm-hmm.
So the person was a parent on a 2-year route.
Mm-hmm.
They were receiving benefit,
Mm-hmm.
and the person was at the same time schooling.
Mm-hmm.
They have now qualified and become a nurse.
Mm-hmm.
This person is working as a nurse, but the question is this: are you working as a nurse on a skilled worker visa or working as a nurse on a 2.5 as a parent? Very important.
Okay.
So if you're working as a nurse based on sponsorship from the company, then you take the benefit of being a nurse, 5 years.
Okay.
But if you are a nurse because you have 2.5 years parent visa, and because of that you have gotten a job that did not require sponsorship, then what is your source of strength? The source of strength is that type of visa, isn't it?
Yeah.
And so the strength will determine how long you have to wait for. So somebody who was already on benefits and is still on that source of strength, which is 2.5 as a parent, they have to wait longer. But if that person converted and applied for a job, but if you have 2.5 years visa, will people normally convert 2.5 to skilled worker visa?
No, not necessarily.
Not necessarily. And therefore, it's difficult for anybody to trade in 2.5 as a parent for skilled worker sponsorship with all the restrictions.
Okay.
So you cannot combine them.
You cannot combine. But even if you volunteer several hours, it would not help you reduce your amount of time.
For the 15 years benefit
Yes.
people.
Yes.
So the voluntary work is standard. So for such a person, remember they said let's assume that the person has enjoyed benefit for 11 months and they've stopped. So they know they have to wait for 15 years.
Mm-hmm.
Already they have their standard 10-year route, right?
Yeah.
Plus the 5 years because of the risk of benefit or punishment for benefit, 5 years.
Yeah.
This person has been able to volunteer extensively to claw back 7 years worth of credit.
Mm-hmm.
Then 15, take away 7 years credit, will give 8 years. However, they cannot finish within 8 years because the standard one was 10 years.
Yeah.
So even though this person will benefit because they've done a lot of voluntary work and they have 7 years of credit, they cannot give them all the 7 years. So they will give them enough to meet the standard threshold they
Of
had
10
before.
years.
Exactly.
Okay.
So such a
Well,
person will be aiming to reduce to the 10, reduce by 5. But the other person who has enjoyed benefit for more than 12 months and they had to wait for how long? 20 years. If they have done extensively and gotten credit of 7 years, then they can enjoy all the 7 years and wait for up to what? 13 years.
right. Thank you very much. Leah, the questions are many and they are coming from all angles. So, with your permission, I will introduce some of them for you to help us answer. But before then, listen, we are live on Facebook at BWF Solicitors and at BWTV. And the program is also live on BWTV. Our social media handles, take note of them. And when we come back, Lawyer Asma will help us answer your questions. The lines are active 0208 493 7345. Send a text to 07399 208 468 or leave them in the comment section down below, either on Facebook or YouTube. Now, check out the handles. Yes, so if you noted them, let's get them going. I have Chipa Jima Pimpon asking a question about the number of hours of volunteering. People Pimpon is saying how many hours of volunteering in a hospital qualifies one for the above. We're talking about the voluntary bit that has between 5 and 7 years.
Yeah, we said that we don't know what the government will say because nobody knows the full length of the new law. Nobody knows. At this point, we are all hearing, we are all listening. The government has said certain things, and we are living by that. But the fine details will come out in autumn, somewhere September, October, November, where they will define how many hours for how many years, where can you volunteer, and so on and so forth. And remember, we said that we don't know where people can volunteer exactly. Remember, we said that.
Mm.
So if we don't know where you can volunteer, then we can't tell how many hours you have
How
to
many
do.
hours you have to.
Exactly. So let's wait. So cheaper. Let's wait for the big boss.
Well, another person is asking, want to know, Emmanuel Setre, mention some of the benefits some people might not be aware.
Right. So before we do that, producer is going to share with us. But before we do that, anything that you have voluntarily applied for and you have been given and you are enjoying is called benefit. Any money you ask from the government
Mhm.
because you can't work and the government gives it to you based on assessment, it is under your name, it is in your name, and it comes into your account, it is called benefit. That's the standard. So if you haven't taken any money from the government by way of applying for support, then this cannot be. So you might have a child and the child's father is British and the child father is applying for benefit for the child. It is the father who is applying, not you, and it is for the child, not you. So you are not a beneficiary. You don't receive benefit. But if you ask for no recourse to be removed and you are receiving the benefit because you can't work, you can't look after your child, then you are enjoying the public fund. That is benefit. But we have a list of them. So producer, let's have a quick look at the list.
So we're going to share that resource with you, Emmanuel, and any other person that's also interested. Public funds, as we have on the screen, if you have permission to enter or stay in the UK, it may include no recourse to public fund condition. Those who do not have permission to be in the UK and require it will also have no recourse to public funds. The condition means you will not be able to claim most benefits, tax credits, or housing assistance that are paid by the state. So let's scroll up. I think there's a list that we can look at. Yes, benefits open to new claims: universal credit, state pension credit, personal independence payment (PIP), attendance allowance, carers allowance, disability leaving allowance, housing benefit, and health in pregnancy grants. So social fund payments meant made in England and Wales and under Section 1381A of the Social Security Contributions and Benefits Act 1992 includes maternity expenses payment, funeral expenses payment, cold weather payment, winter fuel payment, budgeting loan payment. Um,
So I think most people will not go under the social fund and the other specific, but the top one
the
is
top
where
one, yeah.
most people are likely to fall under. Universal credit, the ones you mentioned. So producer, yeah. So these are the main ones that anybody who will go near will be punished for by way of waiting longer for your indefinite. So universal credit, state pension credit. But if you are applying you are going for state pension credit, again, somebody may be on 2.5 year route, but they are of pension age and they are giving state pension credit because of their age. That is benefit. That means if the person is 70 years old and they are waiting to have their 10-year route before they apply for their indefinite and they've gone for state pension credit, then they are going to wait longer.
All right, thank you very much, Lawyer, for that resource. We have more of those comments in the comment section on the text. Let's see if we can pick that. Emmanuel, thank you for your bit. Pippa has come out. Okay, let's pick up the one from Alex. I am wondering if the Employers Act 2025 regarding sick pay from day existing or from April 5 next year. It's not too clear as to what Alex wants to say.
Okay, right. So Alex is referring to the new employers right no Employment Right Act, Employment
Okay.
Right Act 2025. That act was promulgated or was signed into law, but it is effective from the 1st of January 2027.
Okay. All right. Thank you, Alex. Move on to the next one. Chief Ness, what if you work two jobs and you earn 52,000 combined in a year? Does that put you into the higher rate of tax?
So it's not just when we say rate of tax, of course, somebody may be doing two jobs and they are earning 53,000. That is another technical point because the argument will be that I'm one person earning 52,000. But the question is, that 52,000 you are earning, are you earning from the category of a highly skilled worker?
Mhm.
So let's example, you are on a 2.5 years visa. You didn't come in as a skilled worker. You're on a 2.5, and you are doing, let's say, support work, cleaning, could be any work at all, farm hand. And one job you are getting 20,000, let's say 25,000. The other one you are getting 27,000. They are both under 30, and
Mhm.
does that make you a super skilled worker?
No,
No, you are still the
you
same
just
person.
do too many jobs to earn that.
Exactly. It doesn't make you special.
All right, Chief. Thank you for that. Laura, thank you for the response as well. Um, Romeo says somebody came to the UK on a visit visa for 6 months. The person was pregnant for 4 months and delivers in the UK. What is her situation? Is she eligible to stay? And if yes or no, is a child qualified as a UK citizen or a British citizen? Again, will the mother be allowed to stay by virtue of the fact that the child was born in the UK? Laura.
Okay, the bottom line is that a child born in the UK after the 1981 nationality law is not a British citizen. In the US is by soil. In the UK is by inheritance. Inheritance means if you were born to a British mother or father, then you are British. Otherwise, you are a foreigner. So this child mother came to the UK with as a visitor. The mother is a foreigner. The
Mhm.
mother gives birth in the UK. Is the father of the child British? If the father is British, then the child is British under Section 1, Subsection 1 of the Nationality Act of 1981. We
Mhm.
are told from the fact that this person was pregnant for 4 months and delivers in the UK. So the person gives birth in the UK, soil. So this is British soil. Does that make the child British because they've been born onto a British soil? No. Does the child accrues his or her citizenship by way of the inheritance or the parentage? Yes. The mother is a foreigner, so we look at the father. If the father is British or the father has indefinite leave to remain, then the child is British. We don't know anything about the father, so we cannot conclude what the child will become. We can only conclude that if the father is, if because they say that we are told that the person was pregnant 4 months before they came. That means the father is somewhere else. So if the father is also a foreigner, then the child is a foreigner. What is her situation? We've explained. Is the child eligible to stay? And if yeah, no, the child is not eligible and the mother is not eligible. Is the child a qualifying child? No. A qualifying child is the child a qualified UK citizen? We've explained the circumstances under which the child can be automatically British. And that comes under Section 1, Subsection 1 of the British Nationality Act of 1981, which says that if at the time of the birth of the child, one of the parents is British or has indefinite leave to remain, and the child was born in the UK, the child is British automatically. So we have to establish the citizenship of the father to determine what the child become in terms of citizenship. Again, would the mother be allowed to stay because they have a child in the UK? No. The child was born in the no, so we said no. If the child was born in the UK and the child is British because the father is British, then the mother can apply on the basis that the child is a qualifying child under Section 117D, subsection 1 of the Nationality, Immigration and Asylum Act of 2002, and also that the mother is looking after the child and plays a role in the life of the child. And so the mother can stay, even though the mother is a foreigner and an overstayer, entered with visitor's visa. The mother can apply also under Section 117B, subsection 6 of the Nationality, Immigration, and Asylum Act of 2002, on the basis that if the mother leaves the UK, the child who is British cannot survive. That is the only way the mother can survive, and that is the only way the child can become British if the circumstances we have described apply.
Well, that's quite lengthy and straight to the point. And with that, I would want to go back to our nugget because I asked lawyer for some explanation as to what advice we can give to that gentleman who says that he's applying for him to be allowed to stay in the UK because of the status of a child. And the nugget, based on the case Ahmed versus Secretary of State of Home Department 2026 England and Wales Court of Appeal case 509, said that the court confirmed that the ongoing family proceedings will not always delay immigration decisions or removal action. It made it clear that where there is limited contact with a child, weak evidence of a genuine parental relationship, or signs that proceedings were started mainly to delay immigration action, immigration proceedings can take priority. It is important to note that simply starting family court proceedings is not enough. Applicants must show a genuine and sustained parental relationship, active involvement in the child's life, and that the child's welfare genuinely requires their presence in the UK. Obviously, it's a major reminder for parents relying on Article 8 family life claims, especially in cases involving British children, contact disputes, or pending child arrangement proceedings. Early legal advice and strong evidence are now more important than ever. Then I asked lawyer the question as to the case of this, my friend Balibo, or Balibo, as I would say it. Balibo and Ade had a baby, Aki. This baby was born in 2023. The man, Bolibo, was a student, whilst the mother was a British citizen. Ade successfully applied for a British passport for Aki. So it means that the child became a British national. For over 2 years, Bolibo did not show interest in the care of and support of the baby. In 2025, um, the man's post-study work visa application was refused and he eventually became an overstayer. Fearing deportation, he applied for leave to remain as a parent of this baby Aki. His application was refused. He then appealed against the refusal and made an application for a child arrangement order for him to have access to the boy. He believes that he cannot be removed from the UK because he has a pending family court case about the care of the child. So I'm asking, can I say to him as an advice that the pending child arrangement case will not stop his removal from the UK, or he should say that the pending child arrangement case will stop his removal from the UK because the child is British and there is a case ongoing, or neither of the two options would work for him? Now, drop your answers. I gave it to you earlier on, so let's quickly get these answers dropped and see what answers you would have. And then I'll go over to Lawyer Asma for him to help us. Alex says it's number one, the pending child case or child arrangement case will not stop his removal. Okay. Next one, we have Gabrielle, and it says number two, it will. It will stop it. That's what he says. Malam Karim says number one, it will not. The next one is from Ekura Ekia Ofuiwa. It's number two, you say. The next one from Rhoda Poma, number one. Diana Ejewa Frimpong, I think that's what you want to mean, says number one. Thank you, Diana. The next one is from Nanama, number three. Neither of them. Okay, Edmond Austin, number two. Then Kenneth Newton, number one. I think I'll take one more, and because of time, I'll go to Lawyer and see who was right or wrong. Emilia says it's none of the above. Lawyer, that's our dilemma. Now, it's either one, the pending child arrangement case will not stop its removal from the UK. Two says it will. And three says, well, I'm not too sure, I'll sit on the fence. Neither of them will work.
Right.
What will work?
So we explained that where there is clash between immigration law duties and family law rights, we consider the timing of that right.
Mm-hmm.
And if the timing of that right is wrong, then immigration law duty will prevail because delay defeats equity. So where you have right under family law and you don't exercise that right in time, and you only exercise it because you want to avoid some other duty, you will not take advantage of that right to avoid a certain duty because he didn't act in time. So that is the context. Let's apply the law. Bolibo has a right, and the right is that he must be given access to his child by way of child arrangement order. Question: has Bolibo always realized that he had such right? Number two, has Bolibo always exercised the right? Number three, what made Bolibo want to exercise the right now? What is the motivation for Bolibo? Is it because he wants to show that he cares about the child, or that he wants to avoid immigration law duty? Which is which? We realize that he wants to,
from the
context.
second paragraph,
Yes.
it says for over 2 years, Bolibo did not show interest in the care and support of Aki, which evidently is the baby.
So he abandoned a family law duty and he's taking advantage of a family law right at the last minute. But why is he going for the right at this stage? Is it because he realizes that he has a right, or he realizes that he has a duty somewhere? And he realized that he has an immigration law duty to be removed from the UK, right?
Yeah.
And because of that, he ran into family law for right or protection. And the case of Ahmed says that when it happens like that there is a clash. You cannot use the family law right to prevent immigration law duty by the government. And so you have to go home. What it means is that immigration law duty will prevail. And so on this occasion, per the ruling of Ahmed and the Secretary of State 2026, Bolibo will have to be sent home because he didn't act in time to have access to his child. And the reason for accessing the child by way of court order is that he wants to dodge or avoid being removed from the UK. And that is not good excuse. He will be sent away. Answer is one.
Well, Bolibo, unfortunately, that will not save you because you relinquished your parental responsibility. And one thing that has run through our discussion this afternoon is that delays defeat equity. A stitch in time saves nine. Lawyer, how do we stitch in time before autumn 2026?
Thank you. So we have been made aware that the government intends to carry out its proposal of changing settlement arrangement. And we say settlement arrangement, how people can settle in the UK. Before it is time based, now it's going to be so many other factors. So to avoid what is coming, you have to make sure that you prepare yourself. Government has said that anybody who has not had indefinite leave to remain will have to be sure that they are not on criminal record. They have to be sure that they are contributing enough tax and national insurance. They have to be sure that they are speaking English up to college or A level. That is B2. They also have to show that they do not owe any debt in the UK. So if you are preparing for what is yet to come, because you are yet to make your indefinite leave to remain application, then if you are not already on the criminal record, be sure not to get on the criminal record. So mind the gap. The behavior is important. 2, don't go near any debt you cannot pay and don't run away from your current debt. Keep paying. 3, make sure you are working and contributing something to tax and national insurance. Otherwise, you will be punished for laziness. Laziness simply means you don't want to work, even though you qualify to work. Now, for certain categories of people, they don't have to worry. If you are applying for settled status under EU, you don't have to worry. If you are applying for indefinite leave to remain as a spouse of a British citizen, you don't have to worry. Maybe, I say maybe because we are not clear. Maybe if you're also applying as a spouse of somebody who is on indefinite leave to remain, then you don't also have to worry. But we'll find out from in autumn. Again, if you are a parent of a British child or a parent of a qualifying child, it is also saying that you don't have to worry. Now, those people who have to be worried about what is yet to come will be care workers. A care worker will have to wait for 15 years or 10 years, depending. Again, if you enter the UK illegally, you have to wait for about 20 years before you can apply for indefinite. If you came as an asylum seeker, you have to wait for 20 years. If you came as a visitor and you have managed to survive through your child up to this point, again, you have to wait for about 20 years. If you are on benefit and you've been on benefit for less than 1 year, you have to wait for 15 years. If you have been on benefit for more than 1 year, you have to wait for 20 years. If you are working and paying tax and you are paying about 52,000, you are earning, you are receiving your salary of about 52,000 a year, and you are paying the right tax for about 3 years, you can finish the journey and apply for indefinite within 5 years. These are people who are on sponsorship visas, skilled workers, highly skilled workers. And then again, super highly skilled workers who are earning 125,000 a year and they are paying tax and national insurance can finish within 3 years. And this must be shown for 3 years up to the date of the application. We are also told that anybody who is a skilled worker and is offering public service, a doctor, a nurse, a teacher, a dentist, a mental health nurse or practitioner, social worker, pharmacist, all these fall under public service duties. And those people can finish within 5 years. We are told that global talent holders or visa holders can finish within 3 years. We are told that individuals who are able to cut down the time must be people who volunteer to help the community, the church, charities, school, and so on and so forth. For those people, they can cut down the time by either 5 years or 7 years, depending on how long they volunteer for. We don't know how many hours you need to volunteer for to give you 1 year credit. We are yet to know, so we cannot advise on that. Again, we don't know the type of places where you can volunteer to be able to get credit. We are yet to know finally from the law once it is effected in autumn. All in all, the advice to all of us is that if you haven't done or had your indefinite already submitted, and you are going to do it and you qualify, please do it before September. If you qualify, do it before September. Otherwise, you have to go through all these things we are talking about. If you don't qualify, then there's nothing you can do. You just have to wait. But in waiting, you can work towards the voluntary work. You can start volunteering at your school. You can start volunteering at Oxfam, Cancer Research UK, and those recognized charity firms or organizations. Again, you can look at churches such as Church of England or the Catholic Church or the 7 day, not the 7 day. There is a particular church, the church that they wear red. Is it? It's not 7 Day Adventist Church. There is like a military sort of church. Forgotten the name. It's also a British church. Those ones you can volunteer, but we'll get to know the full length of that. Regardless, if you are not there yet, there is something you can do to avoid the danger ahead. If you are on benefit and you have not received the benefit for 1 year, please don't go further. Stop. You lose 5 years, but at least you can gain back the 5 years through volunteerism. Somebody will ask, how can I survive on rent and other things if I don't go near benefit? Well, you can go near benefit, but you have to be prepared for the consequence. It's just a trade in. That is all. So these are the things we've covered. Of course, always get in touch if you need further clarifications or advice on what is yet to come. Thank you.
Thank you very much, and we can't thank you enough for that. For you're asking whether the new changes are being implemented retrospectively.
Yes.
Yes. I paused because obviously it's not the answer you were expecting to hear, but it's yes. So if you have or you qualify for it now, please do it before autumn, which is September, October, so that these new rules and laws will not affect you. But if you wait, they will all kick in. Lawyer, just before we go, I remember at the tail end of last year up to February, I think it was February last year, we were asked to complete some consultation surveys and all that because these things were coming. Are these the ones that are going to be introduced in autumn?
Exactly. Yes. That's the one.
You see how people, when we tell you to participate in certain public activities, we may have foreseen that these things are coming and they will kick in to affect us one way or the other. And when we say you don't mind, a stitch in time saves nine. And I say and again repeat that delays defeat equity. So do it when we ask you to. Lord Charles Asma, thank you very much on behalf of my viewers and the community. Thank you, BWF Solicitors, for your kind sponsorship and encouragement. Thank you to all who have contributed, asked questions. I know we may not have answered all your questions, but at least you stayed on for 120 minutes. That's they are not baseless. They asked, and people were fighting for that because I think there was a point in there that was questioning the timing and the extent to which it will affect. We didn't mind, so they were going to carry on with what they proposed. We didn't mind. We didn't do the consultation well enough. If you look at the statistics, we didn't do it well enough. So we would have to go by their proposition because it's been passed, and the rules will come out in autumn 2026. We did it. Unfortunately, we did it. Anyway, that doesn't stop us from saying thank you to BWF Solicitors and to all of you that have contributed. We have another edition of the Community and the Lord to bring you same time next week. I worked with Shilankra Padmo Dodu. I have support from Romeo Lukaku Udru. That's one of my favorite guys. I call him Romeo Lukaku Udru. He knows the meaning. And Patty Dabs at Tesano in Accra. My studio producer has been Professor Ade. My name is Oreko Fripol. Have a good evening, and I'll see you same time next week.